As many of you know, I'm from Michigan, and so anytime I can blame Ohio for something, I do. And we can blame the entire Student Discipline Act on the state of Ohio, and that's because of Goss versus Lopez. We had some hooligans who started a food fight, and I'm envisioning John Belushi in Animal House going, food fight. So they start this big food fight. And so essentially the principal threw him out of school, didn't give him any process of any kind, just threw him out for 10 days or so. And he just had enough. And the court looked at that and said, well, you know, we generally don't get involved in school matters, but education is a fundamental right. So that was a big declaration. And so they said, if we're going to deal with a federal right, you have to give them some sort of due process rights. Interestingly enough, this was a 5-4 decision, very much along political lines. It was the liberals getting 5 and the conservatives getting 4. I'd be fascinated if this case was decided for the first time today to see how it would go, because that swing vote that we have often, I think it still might come out 5-4, but I'd be fascinated to see. But essentially, you have to give them basic due process rights, and that's notice of what the charge is, an explanation of your evidence, and a chance for them to tell their side of the story. That's really all it requires. If you're going to throw them out, according to Goss, if you're going to put them out of school for 10 days or more, you have to give them those rights. Our states took that down to 5 days, but we'll talk about that in a bit. So the Student Discipline Act, it's 40 statutes. We say this every time, read them. If I was a principal, I would want to have a good working knowledge of these 40 statutes. And quite frankly, you really could probably read 10 of them as a principal. A lot of them talk about the hearing process and appeals and things like that, that really, yeah, you might want to know it down the road, but in terms of actually applying it day to day, there's not that many statutes you have to read. But I think you should read those ones that apply to a principal and master those. But it covers anything that would put a kid outside of school. So suspensions, expulsions, the emergency exclusions, and mandatory reassignment to a different school. So the purpose of the SDA, I like to emphasize this just because I think this was put in place for people like me. I think Clarence Thomas and I are the only ones who think kids should be taken out behind the woodshed with a switch, and there's their due process. But and Clarence Thomas actually said that in one of the recent cases. But anyway, the purpose of the act is to protect kids from discipline. That's really what it is. It's to make sure that their rights are enforced. So it's to assure the protection of all students, their constitutional rights to due process and fundamental fairness. So it's making sure we're not doing what they did in Goss and just throwing them out without getting their side of the story and telling them the evidence. But again, it's within the context of an orderly and effective educational process. So even the legislatures and the courts acknowledge, hey, we still have to be able to run school. Their rights don't run over our rights. The sanctions defined in the act shall be interpreted at all times in light of the principles of free speech and assembly. So again, they're acknowledging student rights there, protected under the Constitution of both the United States and Nebraska, and in recognition of the right of every student to public education. You can see the focus is on let's keep them in school, right? And so we have to keep that in mind. That's the whole purpose of this entire act. So what kind of notice are they entitled to? They get any statement, notice, recommendation, determination. It has to be delivered either personally or by certified mail or registered mail. There is a statute in there that also talks about if they have actual knowledge, which comes in handy sometimes. Typically, you're going to give them in person everything in writing. But if they have actual knowledge, that's going to trump things, even if they didn't get something in writing. Discipline definitions, you should be very familiar with these. A short-term suspension is excluding kids from the schools for any period not to exceed 5 days. A long-term suspension is 6 through 19 days. We are not huge fans of those. We'll talk about that a little bit later. We've got expulsions, and that can vary depending on what the offense is. So it could be the remainder of the semester. It could be the remainder of the current semester and the next semester. It could be a calendar year, and that's for guns. And again, it depends on timing of the offense as well. If something occurs within that last 10 days at the end of a semester, that'll give you some additional time. A mandatory reassignment. This is the Karen Haase special. We'll let her give you her explanation of what it means. But here's what the statute says. It is the involuntary transfer of a student to another school in connection with any disciplinary action. Some people here may read that phrase right out of the definition, but Karen will defend herself here in a bit. An emergency exclusion basically means if they have a communicable disease, you can keep them out. The kids who are making death threats and stuff like that, they pose an imminent threat to others. That's the other time you would use emergency exclusion. We're going to talk a good deal about that and have an example on that one. Other authorized actions. There's a specific statute that says, well, in addition to throwing them out of school for whatever period of time, there's other things that you can do. You can take actions which are reasonably necessary, so you can't act willy-nilly. Is this supposed to be Karen's?
Yeah.
Oh, I'm
that
sorry.
Never happens.
No, go ahead.
She steals from us.
This is
I-
fascinating.
Mark is down. This is the first time I've stolen a slide from Karen Hosey. But anyway, which are reasonably necessary to aid the student to further school purposes or to prevent interference with the educational process. That comes right out of the statute, and we had a case that interpreted that. So I'm going to let Karen take over her slides now. Oh, no. I wouldn't want to steal your thunder.
So one of the things that I think we don't do enough of is think about our other options for student discipline other than suspension, expulsion, or mandatory reassignment. And this list is right out of the statute that tells us all the other things we can do with students short of kicking them out of school. One of the things that I like to do, and some of you have done it with me, is when we do like an expulsion agreement, which we'll explain here in a minute, we say we think your student would benefit from counseling, whether that's an alcohol assessment or therapeutic counseling. Be careful when you use this that you do not inadvertently say, oh, whoops, your kid is special ed and we should have identified him as emotionally disturbed or mentally ill before. But there are lots of situations where kids don't handle anxiety, don't handle stress well, don't handle anger well, don't have coping mechanisms that fall short of a disabling condition. And you can say, we want you to see, get a counselor on the outside. We want you to see the guidance counselor at lunch, that kind of thing. You have that ability. Parent conferences are easy. Rearrangement of schedules. You know what? You can't behave yourself when you're in class with Bobby because you can't leave him alone because you hate him. You're not allowed to be in chemistry anymore. You have that authority, and parents don't have a right really to do much about it. You can keep kids after school. That's lovely. We do have a few parents that say if the kid misses the bus, that's on us. That is not true. If it's part of our authorized actions under the Student Discipline Act, we absolutely can do that. And then you see the last two requirements that they receive therapeutic counseling and the psychological evaluation upon consent. Again, I'm a fan of those, but use them carefully so that you're not inadvertently admitting that we've committed some sort of child fine violation by not verifying the kid under the special education laws or Section 504. Daley is a fabulous case involving an allegation of corporal punishment. The teacher had worked for Bridgeport Public Schools for like 37 years, something crazy like that. He had a physical altercation with the kid, set the kid back down and kind of smacked him on the back of the head. The funny thing about Daley is this guy was actually not fired. This whole litigation was over administrative unpaid leave. And that went all the way up to the Nebraska Supreme Court. Daley and other cases are one of the reasons why I don't think we should do unpaid leave. I figure if we're going to have to go to the Supreme Court, we might as well get our money's worth and fire them. For those whoever's, well, never mind. I was going to make a snarky comment about the unicameral, but I won't. So in the middle of the Daley decision, there's a big discussion about what is corporal punishment and what isn't. And the Supreme Court said some of what Daley had done was corporal punishment. But the thing that we don't always talk about is they said some of what Daley did was not corporal punishment. And the court says that this other authorized action section that we just talked about, those things that were just bulleted on the last slide, gives authority to teachers and administrators to use physical contact short of corporal punishment to the degree necessary to preserve order and control in the school. So the kid that's like, hold on, dude, you can't touch me, or the parent who says, you are not allowed to put hands on my kid or I'll sue you, that's just not true. And Daley, and the Nebraska Supreme Court in Daley specifically says, teachers are allowed to do whatever is necessary short of corporal punishment in terms of physical contact to keep kids under control. My great aunt Eleanor was an elementary school teacher for years, and she was one of my idols growing up. And for a while, she said that she'd been told by Lincoln Public Schools that she wasn't allowed to hug her littles anymore. And then Eleanor, because she was Eleanor, did it anyway. But you see right here, the teacher that says, I don't want to pat a kid on the back, I don't want to high five them, I don't want to give somebody that's fallen down on the playground a hug, you are allowed to have incidental physical contact as necessary to promote personal interaction. So I just think sometimes we get a little, don't smack kids, unless you're Steve. right? Don't commit corporal punishment. But daily does give the authority to teachers and administrators to touch kids short of corporal punishment for a wide variety of other actions. So this brings us to the first question. While Steve reads the text, I was texting with somebody on Steve's phone about the view, and I should have done this at the beginning. If what you want to see is the slides on one side of your screen and us on the other, here's how you do that. Go up to the top of your screen where it says View Options. Pull that down and select Gallery View. Then you'll have like the Hollywood Squares situation happening. Find our video in the Hollywood Squares. Hover your mouse over that. Then in the upper right-hand corner, there'll be a little blue box. Click on that and select Spotlight Video. And then you should have a situation where you've got the slides and us side by side on the screen. And for those of you that haven't gotten that done or are like, well, crap, I don't know how to do that, we are recording this and we'll have the recording posted on the website. And that is the view that we will have on the recording. What do you?
I'm going to go back to the slide to talk about this question.
Oh, okay.
All right, we got a liability question. It says the scenario, female student reports a rape that occurred in the summer by a classmate. School gets law enforcement involved. They want to interview the student in the county it took place in, which is a 30-minute drive. Female student asks the school employee to drive her there because she cannot get there on her own. The male accused is found to be innocent ultimately, but parents are claiming they may sue the school because the school took the girl's side by driving her to the courthouse. Is the school at fault for trying to help the girl report this? Well, number one, as we know, they can sue you for anything. So don't be surprised if that happens. But here's our liability standard. You're reporting child abuse if she's of child abuse age, except for maliciously false statements. I don't see any maliciously false statement here, so I think you're clear under the child abuse statutes. So you can't be liable under those. The Nebraska Criminal Code, the report was false and the person making such report knew or should have known it was false. You didn't make a report. You simply brought the child in for the interview. So that's not even close. The report was made with negligent disregard for the truth or falsity of the report. Again, you didn't make a report. Even if you had made a report, I think you're safe under both of these. I think you're clear. I don't think, again, they could sue you, but I think your defense is going to get this case dismissed pretty quick.
I also will say this, as your lawyers, we wish people like this actually sued you, but they don't. Most of the time, they're just talking out their hat. So I do what's right for kids. You don't have to pretend like you don't believe a rape victim. In fact, I think you're statutorily obligated to report it and facilitate that.
I mean, you clearly had a reasonable belief that something occurred. You had no reason to disbelieve this student. I absolutely would report that.
We'll talk about Title IX as we go here too. So that is one of the things that you'd be factoring into that circumstance. Also, the ability to impose disciplinary consequences for even an off-campus sexual assault is triggered by the filing of a criminal complaint, not a conviction. So we'll talk about that as we go here. And if you attended our Title IX webinar, we talked about that quite a bit as well. But there are a lot of circumstances that have come up where there are criminal complaints filed. That's your trigger for discipline, even if it happened off school grounds. And I think in theory, even during the summer, right? So we'll look at the specific wording of that as we go. Real quick, we want to hit on, I'm not going to spend a ton of time on this, but there is a whole universe of things that you can use as a basis to keep order and impose discipline that is not contained in the Student Discipline Act. That whole universe is the board's authority to implement other rules as long as they're not inconsistent with the act. So for example, we'll talk about things like juuling, the possession of a jewel, right? Technically that doesn't have tobacco in it unless the student, you're able to test it and say, yep, that's tobacco in that, or not tobacco, but a nicotine alternative product in that jewel. One of the things that you can put in a board policy that outlines a rule of the school is not having the little device itself, right? I think you could put in a school rule something like, and a lot of you do have this stuff, you can't wear hats, right? That your student dress code is school board rules that if they're violated could lead to disciplinary consequences, assuming they're constitutional and lawful. So the board has a ton of authority and your policies will have a lot of other rules in them. For example, you've got bullying, right? That's defined in 79267 as a basis that you can actually expel a student if they meet the definition of bullying. But there's no wording of harassment in there, right? Hazing is its own separate criminal law, but the word hazing is nowhere in the things in the statute that you can use to expel students. So a lot of the rules that the school board puts in place, it's the repeated violation of those, any of them, as long as they're lawful, that can also be grounds for student discipline up to expulsion. So if a student, you say to students, hey, you can't bring the little jewel device even if it's empty to school, They do that twice, you can expel them because that's a repeated violation of school rules. Those school rules, when we shorthand that, that is the board's authority to pass those. And so we've got statutes saying that, again, that the board can pass any of those that they want as long as they're not inconsistent with the act. And they can delegate to other school officials a responsibility to pass their own rules and to impose those or enforce those with respect to students. So for example, you could have a rule that says you have to have a hall pass to go to the bathroom, right? The board might not necessarily have that in its policy, but they can delegate to you as administrators the ability to control the hallway during passing periods. If a student doesn't have a hall pass, you could impose disciplinary consequences because that would be an example of authority delegated to the administrators in addition to those rules that are passed by the board. So this universe of stuff we use quite often, right? A couple of schools had circumstances this year where kids brought in look-alike guns. They brought in something that they didn't use it to make a terroristic threat. It was literally just a squirt gun or something that wasn't even a gun, or in one case, it was a cardboard cutout. There's nothing in the Student Discipline Act that says you can suspend or expel a student for having a cardboard cutout gun. If they engage in terroristic threats, if they menace kids with it, sure, now we've got a crime. But what if a kid just brings a little cardboard cutout and takes it out and shows other kids because they think it's funny? You can have a school rule that says you cannot have a look-alike gun. That's nowhere in the Student Discipline Act, but that would be a rule that the board could add to maintain order. So those are just a couple of examples. Any action taken by the board that violates the Student Discipline Act is null and void. So you cannot pass unreasonable or unlawful school rules and attempt to enforce those. An easy example would be all boys can wear the color blue, but no girls can. Unless you've got some sort of rational basis, that could be discrimination on the basis of sex. So that wouldn't be lawful. Any action that you took in support of that rule, because it would violate the Student Discipline Act and state and federal law, would be null and void. Here's why, if you are sitting there starting to kind of eyes gloss over at this point, snap back with me real quick. All of the technical requirements that we're going to talk about for the next 2.5 hours come back to this little phrase. When you call us and say, oh, I already sent the letter to the family, I just wanted you to look at it to make sure I did it right. If we see that you did not do it right, or there was a step that you missed, even if your letter looks great, that action is arguably null, void, and of no effect. So not complying with the material aspects of the Student Discipline Act, like the notice requirements, means that you cannot, you should not, if the parents file a lawsuit, they may very well win, to invalidate all the action that you took. So when we talk about things like, hey, call us ahead of time, call your school lawyer and ask how to do this right procedurally, make sure your forms are up to snuff, your processes are up to snuff. Don't just remember that's how you did it at your last school, because if that action is in material violation of any of the requirements of the act, it's null and void. So the board rules and standards, again, they can make their own rules as long as they're reasonably necessary to carry out or prevent interference with educational functions. We can tie that to about anything, right? The cardboard cutout of guns, that one's pretty easy. And I think it makes sense to have a school rule in that regard. And they must be clear and definite so as to provide clear notice to the student and parent. We see some schools struggle with this part because you write it in a way that is, well, we call balls and strikes. How do you know that that is this, that, or the other thing? Well, we know it when we see it. The person who is having the rule enforced against them must be able to look at that rule and have a clear understanding of how it applies to them.
Okay, sorry, I can't stop myself. When I talk digital citizenship to kids, I have been talking about a case where cheerleaders were flipping up their skirts and taking pictures of themselves. If I've been in your high school and talked about a butt selfie, that's what we're talking about. And it's an interesting exercise because the question is, do you have to say in your handbook, no butt selfies? And I don't think you have to be that specific. But do you have to say students may not take pictures of themselves when they're wearing school uniforms, when those pictures can, cause the school district to be regarded in a negative light? You're getting closer, right? But that wording in your handbooks matters a lot. And what we see is a lot of handbooks that are like an old ramshackle farmhouse that you've built on room after room and nobody's ever tightened them up. Having those written in a way that a lawyer cannot tug on a thread and get after you is money and time well spent. Even though I know this is the time of year where principals are like, God, I should look at the handbook, I don't have time. That is money and time well spent in the bank if you can get it right now so you're not paying us later to fight.
One of the things that I would add on to that is internal inconsistencies provide exactly that argument for the parents, right? If you've got an activity code of conduct that says something different about committing an assault compared to your student discipline, your general academic code of conduct, which rule applies, right? Which one is it that's prohibited? I suppose they could be different between an activity consequence and a discipline consequence, but everybody sitting out there knows chances are that's just because we have not actually sat down and made sure they're consistent. Internal inconsistencies are one of the easiest ways to give parent lawyers a chance to say that your rules were not clear and definite. So we've literally had lawsuits filed on that basis alone, is that it's not really clear which rule they're using to discipline the student. So these are the two things you got to keep in mind when you're writing those rules. And again, school officials other than board members can adapt these rules. The board can change its rules and standards, but those must be reposted. One of the questions we get all the time, hey, we want to add juuling to our handbook. We realized it wasn't in there. That's cool. But all of the distribution and notice stuff we just talked about, giving people notice that it's in there, has to then be redistributed. So if you're comfortable sending out a new link to a handbook and getting parent acknowledgement in the middle of the year, that's great. But to Karen's point, the time to really tackle this stuff is probably over the next few months before those handbooks go live again for 1920. The rules must be distributed to students and parents at the beginning of each year or at the time of enrollment. So you have an option enrollment student that comes in. Sometimes you're not thinking, oh, I better get their acknowledgement in the handbook. Add that to your intake processes. This is the one that if you write anything down, this is on the list of like Mount Rushmore things to make sure you get right. Your school rules, your student discipline policies, your activity policies, anything you call a code of conduct or a rule that you're going to enforce under the Discipline Act must be posted in conspicuous places in each school. So Steve reads the statutes. Karen and I read the statutes also, but a little more loosely. The fact of the matter is that the statute in this regard is clear, and there is no excuse not to have your student discipline rules and standards posted in conspicuous places, right? There's an S on that in the school. So again, rules can be changed, but even if you add juuling to the handbook mid-year, redistribute it to staff or to students and their families, get everybody's acknowledgement, kid brings a jewel into school, you say, ha, I added it this year, I got you now, buddy. But they go to the bulletin board and you haven't updated that copy. That again is a breach of a material provision of the law. You might not be able to discipline the kid. So make sure that you've got them posted in conspicuous places and that you've made reasonable efforts to redistribute those. I think a reasonable effort is replacing the one on the bulletin board because that's a pretty easy one to change.
Plural.
What?
Places.
Yeah, places, right.
Yeah.
Yes. So not one place, obviously. If you have it, for example, any different wing of the school, put it there. If you have a bulletin board for announcements, put it on both of those. But make sure that it's at least in more than one place. If we come out for a student discipline hearing, one of the calls we'll make before we come is, hey, just to be clear, I want to be able to have you walk me around to the places that is placed in the school. So make sure that you can do that. If you do that now when you go back to the district today, or if you're there, go out and check that that's happening.
I have to admit, I always find it amusing when we have to put it in conspicuous places. That was written by a lawyer or put in there because of a judge's decision. How many kids do you know that stand in the lunch period and just start flipping through your student discipline thing that's posted? But anyway, jurisdiction and authority. There are limits to what you can do based upon where these actions or students' actions occur. And a couple of questions you're going to want to ask is, did the incident occur on school grounds, in a school vehicle, or at a school activity? You're going to hear that repeatedly. We kind of steal second base a little bit. And part of this is because this act was put in place in 1976. Computers, especially laptops, weren't very prominent in 1976, as you may recall. Karen certainly does.
Hey.
So we read property to mean school grounds to be property, so that if they're using a school computer, iPad, whatever piece of material it might be or piece of equipment it might be, we consider that school grounds, unless and until we're told otherwise by a court. Clearly, that was the intent of the statute. It just didn't exist at the time. So that's how we read it. So you'll look here, location of offense. Look at that list: long-term suspension, expulsion, or mandatory reassignment. What is missing from that? Short-term suspension, emergency exclusion. So keep those in mind. So the location of the offense only applies to long-term suspension, expulsion, mandatory reassignment. Has to occur again on school grounds. This is right from the statute: school grounds, school vehicle, school-sponsored event or activity. So those are the locations of where it has occurred if you want to do one of those three disciplinary techniques. Where does this come from, or what do we do if it occurs off campus and it's causing problems on campus? We've got the Tinker case. We were lucky enough to see Mary Beth Tinker, and I believe that's her brother, John. I'm not positive, but that's Mary Beth. We saw her. They were celebrating the 50th anniversary of this decision. And so we had a chance to see her speak, and she still goes around the country and appears and talks about this case and still advocates for student rights. But this was the black armband case back in 1969. The school became aware that they're planning to do this, so the principals adopted a policy saying, no armbands in school. That's not going to happen. So the kids showed up, the Tinker kids in particular showed up wearing their armbands, and they get suspended. ACLU jumped in and sued, and the students ended up winning. And this is where we get our famous phrase that you're going to hear in all these presentations about student discipline. Students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. So what does that mean, though? They don't have unfettered ability to do whatever they want. And what do we do when something occurs off campus, but we're pretty sure it's going to cause a problem at school? Well, the court addressed that, and they said the school would have to prove facts which reasonably may have led school authorities to forecast substantial disruption or a material interference with school activities. It's kind of a delicate balancing test, and that's one where this is where we would want you to call if you're planning to use that piece, because it's tricky, very fact specific. Courts in one part of the country would rule one way, whereas courts in another part of the country would rule another way. So that I would agree with you if you're going, hey, what the heck does that mean? We can't give you a bright line rule. It's just impossible. But just keep in mind that the fact that something happened off campus doesn't mean your hands are completely tied. Okay, so even if the incident occurred outside of school grounds or outside of school vehicular activities, you get to ask the following questions. Did the incident cause you to reasonably forecast a material and substantial disruption of school functions? Especially think about the death threats. They find that I'm going to kill these people list at home. That's never been in school. It's never been discussed in school, but now it's out there. Is it reasonable to forecast that that's going to cause a disruption? Absolutely. Did the incident actually cause a material and substantial disruption of school functions? That, again, we would want to talk to you about the specific facts that you have. A lot of times the answer clearly is yes. Yes, they do. Did the incident reasonably cause another student to miss school functions or school activities? And I think you can add in there even a teacher, if a teacher has to miss because of, and we've had those cases where a student threatens their life in such a specific manner that they are freaked out and kind of have a meltdown and a breakdown. And so that's very real. So those are the things you need to consider. We're going to talk about what you can do in terms of short-term suspensions and emergency exclusions when those events occur.
All right, we're going to get into this hypothetical. We'll be looking at a break here in a second. All right, Karen, it's going to come.
Sorry. I just didn't want to forget. On posting of school rules, one of the questions that we kicked around yesterday was, can the conspicuous places be on your website? And the problem is when they wrote the statute, the interwebs did not exist. And so it's going to be hard for us to argue that the website is adequate. I think website can be one of the places that you communicate it, but I think you also should make a photocopy and put it on 2 bulletin boards. So that I just didn't want to forget to say that.
No. I want to add one thing. Whenever I come and do an in-service for staff where I talk about things like your role as a teacher in helping both yourself and the school document these things like material and substantial disruption, judges love it if you can point to disruption of class time. Yes. And the problem that we see in documentation is exactly this one. So if you're going to go back and at the beginning of next year do some in-service training on documenting for your staff, don't just write down, Steve had an outburst in class. Steve had an outburst in class, comma, and it took me 37 seconds before I was able to redirect Steve and get back to instruction. That 37 seconds to a judge is hugely important as compared to we had a disruption in class. That statement as a fact is great. It's probably objectively true that you had the disruption. What judges want to see is what disruption was that? What school function and process can we point to? And they love it if it's disruption of the actual education taking place in the classroom as compared to a redirection at a lunch table or at recess, right? They weigh these things based on your purpose of educating kids.
Cody and I were just doing witness interviews for a personnel hearing, and one of the issues was an email that the teacher had sent to all the students. And multiple teachers told us that kids were talking about it and whatever. But one of the witnesses said It took me 13 minutes to get the kids refocused on the subject matter, and my class is only 47 minutes long. That was golden. And so, I mean, it's just that specific example made all the difference in the world in terms of us being confident we could establish disruption pursuant to the Tinker standard.